And here we are, part 4, chapter 6. We were talking about liability disparity, some courthouses that are pretty tough. How about some that are pretty generous with respect to plaintiffs? A number of courthouses in Mississippi and Texas historically have had the reputation for being very generous with jury awards. So it was common up until a relatively few years ago for a lot of asbestos cases to be filed in these jurisdictions that might be relatively small, but they're ones where those courthouses were known for giving pretty big jury awards. With respect to the LA area, downtown is considered to be a pretty generous place with regards to jury awards. Civil Central West, which is located at 6th and Commonwealth, not far from MacArthur Park. It's changed a little, but in the old days, that's where longer trials would be, at least 20 days in length. And that courthouse was known as the bank. So if I had a defense case, I did not want to be there. If I had a plaintiff case, you bet I wanted to be there, or my client wanted to be there, because they were known for pretty big jury awards. Compton tends to be historically pretty favorable to the plaintiffs. The last example I want to give is one that has totally turned over the years, and that is Santa Ana in Orange County. Historically, Santa Ana was a very difficult place for plaintiffs to prevail, very conservative, but as the demographics and the politics of Orange County have changed over the years, Santa Ana has become much more favorable for plaintiffs. Now, as a lawyer, do you have a lot of say as to where you might be? Only to a degree. Strategically, there are situations where you may file in different jurisdictions, but you don't have a whole lot of say. And in LA, you can't control where your case is ultimately heard. So it may be just that, like the day before trial, that you're going to be in Lancaster, you're going to be in Long Beach, you're going to be in Pomona, you're going to be in Beverly Hills, or wherever the circumstances might be. Okay, now we mentioned briefly with regards to a tort, there are 3 elements, similar to the 3 we had with contracts, but it's different, obviously, here in these non-voluntary situations. You had injury to the plaintiff, you had the causal factor for the injury coming from the defendant, and then a breach of duty owed to the plaintiff by the defendant, not to be reckless, not to be careless, etc. Okay. Obviously, what we are focusing on in this chapter is going to be the 3rd element of the tort. How do we determine whether someone's liable, etc.? And we're going to spend a lot of time talking about that. But I want to talk for a minute about the second one, because sometimes the cause of the harm is not obvious. For instance, take asbestos cases. You may have worked around a lot of different products over the years. You may have been simply exposed to a lot of different products that contained asbestos. How do you determine that it was one particular firm's product that contained asbestos that is the cause of your illness as opposed to someone else's? Well, you have to do what you have to do. So jurors sometimes have to apportion liability. So a certain percent is caused by one product, a certain by another. It's an inexact science, to be sure. Auto accidents, pre-existing conditions. So if someone says, oh, my neck hurts, my back hurts, injured this and that, particularly soft tissue injuries where you haven't broken a bone, a lot of times, a lot of times, the defense is going to come in and go heavily through someone's medical history. They're going to subpoena their medical records and see that, oh, they went to the chiropractor 10 times in their life. They have these aches and pains on an ongoing basis. So we're going to argue that it was not caused by the accident, or if there's any impact, it's kind of minimal. And so a lot of the fight in those cases take place with the doctors, arguing that it is causally related to the accident or not causally related to the accident. How about existing illnesses? In the toxic tort world, besides the causation with respect to who caused what, there's another issue, and that is to what extent has someone really been damaged and for how long? So it is not uncommon. In fact, it's the norm in an asbestos case that I will be asked a lot of questions that, well, did you know that the person who's dying, they had diabetes, they had COPD, they had high blood pressure, they had this illness, they had that illness, they were a smoker, etc. And I said, well, how would that affect your analysis? Wouldn't affect my analysis at all. I'm not that kind of doctor. So we would rely on the medical experts to determine whether someone had a pre-existing condition or not. A client of mine speaking at the Lawyers Convention a number of years ago in Las Vegas gave a talk during one of the continuing education sessions and brought up the following point. Take someone who's 50 years old and gets into an accident, they get hit by another car. Is there anyone 50 years old who doesn't have a pre-existing condition? And so the point he made is kind of well taken, that this stuff is thrown out all the time, but hey, the life tables already factor in pre-existing conditions and whatever the health is of someone, a given age, gender, ethnicity, etc. So it becomes a battle, and it's a battle ultimately there over damages, because if you weren't going to live that long, then the loss associated with your premature death not going to be as great. Okay. One final point that I want to just make real briefly, and then we'll get on to item number 3, is the defendant's action legally must be the proximate, Proximate, cause of the harm. In other words, it's got to be substantially related to it. So again, showing causation. And so the legal determination is that it was substantially related to the accident. It doesn't have to be the only thing that caused the aches and pains, but it's got to be the main thing that caused the aches and pains. Now, the third element of the tort is the biggie, okay? That's where there's a breach of a duty that's owed to the plaintiff. Without this, if we didn't evaluate a breach of a duty, every case, once you establish someone got hurt and then someone caused the hurt, would be considered strict liability, and the defendant is automatically guilty. All you have to do is prove causation, okay? Now, strict liability, you might say, well, yeah, that really makes sense, but wait a second. People can contribute to the severity of their accident. Somebody slams into you as you're driving, totally their fault, but wait a second. You may be partially responsible because you weren't wearing a seatbelt, okay? Or you were driving recklessly yourself. So strict liability would not even bring any of that into play, okay? I mentioned this on a previous video. Someone jumps out into the street between two parked cars and you don't even see them, okay? I know someone who got into that kind of an accident. I think the person died, but they were found not liable, even by the cops, because the person, there was no notice. It was, think of the last clear chance rule. There was no last clear chance rule to deal with, okay? Those are the exceptions. More normally, we do need to show fault, and we're going to deal with strict liability and no liability in more detail, and some of the questions that I've assigned to you are going to address that as well. When a legal duty is breached, we have negligence, and that's what you have to prove, okay? If it is willful conduct, that's going to be criminal. So we're really referring to negligence. The person was staring at their phone. They're not allowed to have the phone out, so they have it in between their legs, or they're looking down at text messages while they're driving. They weren't paying attention. They didn't see the light change, and they went through the intersection against a red light. Those would all be negligence, okay? And the breach of duty is typically not going to be simply yes or no. Sometimes it will. Was their seatbelt fastened or not? Other times it won't. Medical malpractice, for example, which is clearly a tort, is up to the judgment as to whether or not the treating doctor or hospital or nurse or whomever the healthcare provider was, were they within the standard of care or not within the standard of care? What if you are driving, but you're not speeding, but you've been charged with reckless driving? That's, again, that's not black and white. That's going to be a lot of shades of gray, okay? So circumstances like that, it's going to be, it's going to be pretty tough to figure out who's guilty of what. A legal standard, though, at least gets us down the road of figuring out whether the defendant was negligent or not. Okay, so I want to end part 4 of this video by showing you a simple diagram that would illustrate that. Okay, and so this is going to be a very common theme in this chapter: precaution. This is how much care the individual took. Okay. You have a question relating to speed limit that I've assigned, so I'm not going to give that one away. But here we've got a continuum of no precaution whatsoever up to an ever increasing level of precaution. Safetiness, the speed at which you're driving, how careful you're driving, signaling when you're changing lanes and stuff like that, okay? X tilde, X with the squiggle, will be the legal standard that's set, okay? And hopefully, I think X star is the way we come up with the efficient level of precaution. We will hope that this is set at the efficient level of precaution, but we don't know. But at the very least, this will be the legal standard. Any level of precaution below it, you're in the forbidden zone and you're going to be at fault. So anywhere here, you're going to be found guilty. If you are at X with our squiggle or greater, then you're going to be in what we call the permitted zone and you're not going to be at fault. So if X is greater than or equal to the legal standard, then you're in the clear. This is a perfect example of someone arguing that they were not speeding when they got into an accident. Okay. All right. Part 5, we'll continue on this.